Good morning, everyone, and welcome to Conducting Investigations for Charities. What we've seen is that investigations are more under the spotlight than they have been. Charities are being held to account not only for whether they do investigations, but for the adequacy of them. And we thought it may be sensible and helpful indeed, to do a session on it. Sorry, I've just been dive bombed by my cat, so apologies. Today, we're going to cover an initial view, and it will inevitably be a relatively brief and short overview on the issues relating to investigations. Myself, and I'm a regulatory compliance partner, and Joe Oliver, an employment partner, will look at some of the fundamental issues and building blocks for building a suitable and sufficient investigation into the issues you're thinking about. And we'll also try and explain the different requirements depending on the type of investigation that you're dealing with. For those of you who are independent schools or associated with an independent school, we do have a day-long course exploring these issues in more detail and with some practical guidance on the 10th of November in our London office. That's a paid-for event. And for those of you who aren't independent schools but would like a similar course, do please let us know. And if we have sufficient of you interested, we will definitely arrange one. So, Amy, if we go on to the next slide and we just start with the introduction, just thought it may be helpful to remind you all of the trustee duties. I appreciate not all of you will be trustees yourselves, but of course you'll be helping the trustees to fulfil their duties. And what I've done is reproduce those that are set out in the Essential Trustee, which really is key guidance for trustees and for charities around performing their legal duties. Not all of these will relate to investigations, but just as to pick some of those out from that, the charity is required to comply with its legal and regulatory requirements. And for those, you're going to be needing to make an annual return and to comply with your serious incident reporting duty. And in order to do that, you need to explain what's happened and what the trustees are doing about it, which tends to involve an element of investigation. You need to act in the charity's best interests, and that means making balanced and informed decisions, thinking about the short and the longer term and managing conflicts, all of which are relevant factors when it comes to thinking about investigations. And you need to give enough time and thought to the issues you're grappling with in order to discharge the duty to act with reasonable care and skill. Essentially, the trustees have an obligation to demonstrate that the charity is compliant, that it's well run and that it's effective, and undertaking appropriate investigations is key to that. Alongside that, we've got some real themes that we're seeing coming out of the Charity Commission's guidance, coming out on other guidance that they're endorsing, and what we're seeing from the inquiries they are undertaking into charities where they have concerns. And those two themes are actually picked up in the Charity Governance Code, which the Commission endorses. One is about integrity and about acting in a fair way and treating people with dignity and respect so that when concerns are raised, you look into those in an appropriate way. And the other is the expectation around openness and accountability, which again tends to require not only that you do an investigation, but that you share outcomes with people in the appropriate way, and that you are willing to reflect on the way that the charity does things and to learn on that, learn from that. Okay, So if we move on to the next slide, this is not an exhaustive list, but what I wanted to just demonstrate to you is how very wide and diverse the circumstances are that might require an investigation in your charity. And what you'll do if you start looking at these things is realise that you're not going to be able to have one procedure or one framework which is likely to cover absolutely everything that you might be dealing with. And one of the issues that we quite often help trustees and charities to deal with is thinking about scope of investigations, about whether you're looking at one particular incident or whether you're looking at wider issues relating to culture, which is another of the matters that the Commission is particularly interested in, especially when it relates to protecting people from harm and supporting them. So that will, of course, inevitably have an impact on how you go about what it is that you are planning. And the principles that we'll be talking about today should apply to everything that you're doing, albeit that, as I mentioned, there may be different practical ways that you discharge them. And if we move on to the next slide, what we quite often see is that people realise something's happened and they think, gosh, we must investigate, and they launch straight in. And unfortunately, it becomes increasingly difficult to unpick that if there are some issues about it. And I always think it's worth pausing and reflecting on what the preliminary issues are before you actually launch into the scope and commissioning of your investigation and then the actual conduct of it. And this will be a list that may apply to many of the things that you're doing, and happy to share and talk through in more detail. But of course, you're going to want to manage ongoing risk of harm and indeed loss that may be occasioned to the charity or those affected. And quite often, there are going to be people who are involved who are going to need support, and that may not be just those who are the subject of the issue that you're investigating, but those who are perhaps more tangentially involved. So do think about those as a priority. I always put preserve evidence as an early step. People will quite often think, oh, what do you mean by that? Do you mean, you know, the materials that were found at the source of a fire, or do you mean the nasty note that was left in someone's locker? Yes, it may be those sort of things, but actually more and more it's about social media posts. It's about thinking about what's on your IT system. It's about thinking about your CCTV. Because quite often organisations will have those on loops where they get wiped. So do think about that aspect. Of course, you'll need to fulfil your reporting obligations, both internally, and you'll have a mechanism about what goes up to various levels within the organisation, including to the board, and externally. So, for example, there'll be certain matters, criminal offences or allegations of them that need to go to the police, matters that need to be reported to the Charity Commission, matters that need to be reported to other regulators that you'll need to factor in relation to that. And the reason it's important to think about that at the outset is that they may then have a view about what and how you might investigate matters yourself. So I've mentioned on the slide about just remember that there are some obstruction offences and that the police may not be happy with you launching into an investigation which cuts across what they themselves are doing, HSE similarly. So you do need to have a dialogue with those in certain circumstances to make sure that you can cover what you need to. And of course, for this session, the million-dollar question, consider the investigation. And there may be related matters, such as the need for suspension of staff while that's happening. I mentioned that Jo, my colleague, is an employment lawyer, and she would normally deal with those sort of issues and advice on it. Jo, is there anything you'd like to add at that stage?
I suppose one thing when you're thinking about suspension is it justified? What is the reason why you're suspending? Because it should very much be a last resort. You would want to be thinking about, is someone at risk? Is having that person in work posing a risk to others around them? Could they be tampering with evidence? Could they be influencing witnesses? And those would be reasons why you would suspend. And you'd need to think about making sure that the suspension lasts no longer than is absolutely necessary.
Thanks, Jo. So moving on, we've got the PR piece, but much more broadly than that, the communication and information sharing piece that you'll have with those within the charity and your stakeholders that you need to think about. And fundamentally, the advice I would give in relation to that is making sure that what you say is factually accurate and knowing what has been investigated and you can say with confidence, and what perhaps is not yet been determined. I always talk about recording decision making and outcomes. It's really important that you do it. Even if you decide not to do things, it's really helpful to record why you've made those decisions. And as you go through the process, there may be findings that are made and recommendations or actions that are taken. And it's important, again, that those are documented so you can see the audit process as you've gone through the event that you're dealing with. And then you need to have some process of review and reflection, not only looking at the particular issue or incident, but more broadly about trend analysis and whether there's anything else that you need to take action to improve within the charity. So if we move on then, Amy, I want to just spend a little bit of time thinking about what is an investigation. Quite often, I find that people get quite caught up in what we mean by it. Is an investigation a fact-finding exercise? Does it need to involve interviews with people? Does it need to involve a report? What's the difference between an investigation or a review or an inquiry or an analysis? And essentially, there isn't a universal definition in relation to these things. From my perspective and what I deal with, it is a fact-finding exercise, and it's then for the charity to determine what it's going to do and how broadly it's going to cast its net in order to undertake that in terms of scope and methodology. But it is different in an employment scenario, so I'm going to hand over to Jo, who can talk to the ACAS guidance on it.
Thanks, Tabitha. So yes, from an employment perspective, carrying out an investigation is a fundamental part of conducting a fair process. It forms part of the ACAS code of practice, and therefore when you're dealing with a disciplinary or grievance matter, if you don't investigate properly, it could result in an uplift in any compensation should that employee bring a claim in the employment tribunal. And also carrying out a thorough and fair investigation goes to the overall fairness of any dismissal. And will be a fundamental question that's asked, is the dismissal fair in all the circumstances? And if you can't show that there was an investigation which allowed the decision maker to form a reasonable belief of someone's misconduct, then you're not going to be able to justify that dismissal and would be on the hook potentially for compensation. Amy, if we move on to the next slide, please. And if we look a little bit more at the whys of investigation. So there's a full range of reasons why you would investigate a complaint or allegation. We've set out some of those reasons on the slide, but fundamentally it's about understanding what's happened. It's about having all of the information to be able to make well-informed decisions for your charity. And it also enables that robust decision-making process. Those principles apply not only to employment investigations, but across the board at any kind of investigation. A thorough investigation also promotes fairness and supports all of the people involved. It's important that a charity is seen to take allegations seriously and that it's committed to establishing what's actually happened. For the individuals who have come forward and who may have been reluctant to come forward with their concerns, it provides some reassurance to them that they're being listened to, that they're being heard. And for the person or persons on the end of the allegation, those who are subject to it, it provides them with a forum to provide their account of events and to put forward any evidence in defence of the allegations against them. So in terms of your duty of care, it ensures that you're taking things seriously and that those involved feel that they are actively involved in the investigatory process. It also reduces the scope for the charity to be criticised for turning a blind eye potentially or covering up wrongdoing. And this in turn engenders trust and confidence in the charity and creates a culture of transparency, which Tabitha's already talked about, the Charity Commission and regulators wanting to see that level of transparency and integrity. So in addition to those reasons why, you may have policies and procedures that actually prescribe an investigation should be carried out. And from an employment context, the most straightforward examples are disciplinary and grievance policies, which will set out an investigation, who should be carrying out that investigation. There will be other employment policies as well that require complaints to be investigated. Disciplinary and grievances are very much about the individuals concerned, but there may be, under your whistleblowing policies or your dignity at work policies, a requirement to investigate wider concerns about cultural issues within the organisation, particularly any allegations of institutional discrimination or organisational wrongdoing. And other issues like capability, for example, would require some level of investigation to understand any medical restrictions on a particular individual that might be affecting their ability to do their job, and evidence gathering there of that medical information. So investigations are a critical part of discharging a duty of care and showing that your charity is seriously considering these issues and is committed to addressing them. There's also the wider safeguarding issue that the charity has in terms of protecting those that come into contact with it from harm. Tabitha, I don't know if there was anything else you wanted to add there in terms of the why investigate.
No, other than lots of good reasons to do so and to know what it is you're dealing with. That's the sort of carrot aspect, and I think you're going to go on to talk about the stick one in a moment.
So if we move on to the next slide, as Tabitha just said, those are the positive reasons why you would investigate. The negative and the flip side of that is the risk that if you don't investigate, what could happen to your charity. So the clear issues there are claims from an employment context. If you don't look into an employee's concerns, if you don't address issues of discrimination, for example, you will find that those who don't feel that they've been heard will look for another route, and that route is often the employment tribunal. So you may end up being issued with a claim, and if that claim is successful, the individual will be compensated. There's the risk of regulatory action if you don't take appropriate steps. For example, data breaches, if you're not dealing with those and you're not reporting, there could be regulatory action from the ICO. And a key issue as well is the adverse PR that comes from not investigating or being seen to cover up or conceal wrongdoing or not being interested in finding the source of the issue. Social media issues can blow up very quickly and can have a very, very negative impact. And also cost implications, damages, compensation, all has cost impacts on the charity. Anything else you wanted to add there around risk management, Tabitha, before I move on?
No, not at all. Thanks, Jo.
Okay, so if we go to the next slide, please. And this looks at commissioning the investigation. So looking at who should be conducting the investigation. From an employment law perspective, it's very clear that different people should be doing different parts of an investigatory process. So you would have the investigator, and then you would have the decision maker being separate people. And you would also need to reserve someone to hear an appeal if it's a disciplinary or grievance matter, for example. So at the early stages, you'd want to identify who those people are. In a small charity, it may be that you don't have a particularly large management team where you're able to separate those responsibilities. And in those circumstances, you might look at bringing in an outside consultant, for example, to do the investigatory part of the work and reserve a senior manager to make a decision at the end of that investigation, and to reserve possibly a trustee to deal with the appeal. And we often see that trustees are brought into matters within charities at the appeal stage. You'd also need to think about whether the investigation should be formal or informal. This very much depends on the seriousness of the complaints that have been raised. In most cases, and particularly within employment policies, you would often try to advocate for de-escalation at an early stage, which an informal process can bring about. However, that doesn't fit all circumstances, and informal resolution is really only appropriate for minor issues, and ones where there isn't a complicated factual matrix where you can see what's happened fairly clearly and you can intervene. For serious issues, particularly issues around discrimination, harassment, it's appropriate to move to a formal investigation fairly quickly, but that shouldn't be at the expense of scoping out that investigation clearly and working out what those allegations should be. With employment issues, often your policies and procedures will point you to who should be doing what in a process, so it's important to refer to those. You need to be thinking about time limits. So from an employment law perspective, employees have generally 3 months to bring claims, and you would be wanting to ensure that you're actively investigating and dealing with issues within those timeframes, possibly much quicker than those timeframes, to prevent a situation occurring where an employee feels that they have to issue a claim so that they are protecting their position. You want to try and resolve it internally so that they don't feel that they have to go down that route. There are also other time limits that may be set by regulators in terms of complying with investigations, and the overarching principles as well of adopting fairness and avoiding conflict in terms of who is involved in the investigation. So making sure that whoever you appoint as the investigator or whoever has a general oversight of the investigatory process isn't named in the allegations at all themselves, or wouldn't be conflicted or prejudiced in terms of the outcome of the investigation. And then the final thing to talk about on commissioning is about reasonableness and proportionality. Certainly from an employment law perspective, you would look at the resources of the charity, the size of the charity, in terms of determining the scope and the extent of the investigation and the resources that you put into it. And the key factor as well is the seriousness of the allegation or incident that you're looking into. You'd need to make sure that for a very serious issue, you're putting in the resources that are needed to be able to get to the bottom of what's happened, and to be seen to be reasonable in your investigatory work. Tabitha, is there anything else you wanted to add there?
I think that this is the fundamental piece that often people miss out on. So if you were going to take one piece away from today, that time that you spend planning what it is that needs to be done and how, I think is really essential. And I think that we can write nice, neat bullet points, but actually when you're within an issue and within a charity which may have conflicting policies and procedures or different ideas about what needs to be done and how, or regulators, as Joe said, imposing quite a lot of pressure into the way that things are done, and those affected also having real sort of personal interests, it can be really difficult to decide what to do. So absolutely, I agree that that you need to treat it seriously, and this principle of fairness is essential. And I think that rather than just think about the trustee management of conflicts, it's also worth thinking about perceptions that we've talked about here, about loyalties, and about the extent to which the charity internally is able to make decisions about the whole process, or needs some external assistance in dealing with it all. And unfortunately, it's a bit like when you're planning these things. It's a bit like buying a house, that these things inevitably snowball. When you're doing one up, that what you start off as your budget will quite often sort of gather momentum and increase. And thinking about, as Joe said, the degree of risk, I think, and protection of people is a really sensible way of addressing the reasonableness and proportionality piece.
Thank you. So if we move on to the next slide, and we'll look at terms of reference for an investigation. So this is a really key document because it sets the scope and parameters of the investigation, and it often gets referred back to, and it gives your investigator the guidance that they need to run the investigation and to get to the heart of the issues that you've identified. So the terms of reference would need to set out the issues clearly and identify the allegations. It should state whether you're looking for the investigator to make any particular recommendations. From an employment law perspective, what you wouldn't want your investigator to be doing is making recommendations on sanctions. That should be reserved to the decision maker. The terms of reference would also need to set out the methodology that you're expecting the investigator to follow, or a stipulation that they explain in their report what methodology they followed. You would want to highlight how you want the findings from the investigation to be delivered to you. So whether you want that in an oral presentation or in a report. So a written report would always be our recommendation, and certainly good practice for employment issues. And you would also want to provide signposting to any relevant policies, documents, etc., that the investigator would need to see, and to make sure that they are available to the investigator too. Quite often within an investigation, as the investigator starts to speak to relevant witnesses or look into documents, other allegations can crop up, and the terms of reference should highlight how you deal with those. So should the investigator come back to the charity or the person within the charity who's commissioning the investigation to confirm whether that allegation should be added to the investigation, whether it should be dealt with separately, and if new allegations are going to be incorporated, the terms of reference should be updated to reflect that, so that it can be a movable document in that respect. And having that clear parameter set for the investigation stops scope creep, that the investigator could go off on a tangent, could be using resources in a way that wasn't intended, could be looking into wider issues than were the issues that the charity wanted to be covered by the investigation. Tabitha, was anything else you wanted to add around terms of reference?
I think there are a couple of things that we see in the non-employment scenario, because we've got a bit more freedom and latitude to do what we think is reasonable and proportionate. We're not as constrained by process. So one of them is people say, oh, do you have a terms of reference document? Do you have a template? And we don't actually, because they are so individually determined. It doesn't need to be anything more than an email. It's about people being clear about what others are being asked to do. So that's the first thing. And the second is that where employment talks about the different people doing different bits of it, we don't have that same need for straight lines on all of that in other sorts of investigation. And you may decide it's better for people who know the organisation and are within it to actually undertake not only an investigation into what happened, but to consider findings and recommendations at the same time. It will be very fact specific.
And I suppose once you've got your terms of reference in place, the key thing is to identify who you should be appointing as the investigator. So if we move into the next slide, we can look at some of the things that you should be thinking about. And that slide will set out that list of issues. But the main thing is to make sure that the person's suitably qualified, that they have experience, that they are sufficiently senior enough if they're within your own organisation to be able to probe the issues, to report back and not feel that they are fettered by line management. They need to be unconflicted, so they shouldn't be someone who's been involved in any of the issues. They shouldn't be under the line management of anyone who's involved in those issues. And quite often within a charity context, sometimes having an independent investigator who is external, who can come in with the relevant experience, is very helpful, particularly around very sensitive issues or issues that affect senior management, or issues that are considered to be institutional, and they might have the objectivity to be able to come in and see things a little bit differently than someone who is part of that institution. You need to make sure that the investigator has the time to devote to the investigation, that they haven't got a lot of competing commitments that mean that they're not going to be around, because investigations need to happen and move forward. There shouldn't be unreasonable delays. You need someone who is sensitive, even-handed, compassionate, that understands it's a stressful situation for the people involved. And they need to be critical. They need to look at the information. They need to be open to seeing things from both perspectives, and looking for information that supports the allegations and also information that would undermine those allegations. And they need to put together a sensible report that is chronological, that is structured, and that really assesses the information that they've been able to gather. So they need to be literate in that way to be able to deliver sensible findings. If we move then on to commissioning, to undertaking the investigation, so the main event really. Once you have an investigator appointed, and the terms of reference are in place, they need to commence the investigation. So the overarching principle is that they need to do that in a fair and balanced way. They need to be able to access the relevant information, and they need to really create a plan of how they're going to go ahead with the investigation. So they need to think about what policies, procedures are relevant here and to review them. They need to think about any physical evidence. So is there CCTV? Are there documents that they need to review? Do they need to look at those first before interviewing witnesses, or do they need to speak to the people concerned to get an understanding of what the allegations are, to view the physical evidence in the context of those allegations? They need to set their time frame in terms of when they're going to do the interviews, and they need to think about the order that they're interviewing the witnesses in. When they're contacting witnesses, they need to be clear in what it is that they're doing, what their role is, so that particularly within employment, there's no ambiguity, and the employees know that they're being asked to attend an investigatory meeting. For the person who might be the subject of the allegation, there needs to be thought given to how the allegations are framed to them. Ordinarily, you'd want to be as transparent as possible, but you just need to think about, could putting them on notice about what you're going to ask them about lead them to destroy evidence, do anything that is going to undermine the investigatory process. There's not a statutory right to be accompanied to an investigatory meeting in terms of disciplinary matters, but the investigator would need to think about, actually, would it be helpful for an employee to have someone present? Would it make them more comfortable? Would it make them more open in terms of the information that they provide? With grievances, any information that's gathered through an investigatory meeting from the person who's raised the grievance, they would be entitled to have a companion, so a work colleague or trade union representative, attend with them. And there would need to be thought about what's proportionate and what's reasonable in terms of how wide the investigation goes. So how many witnesses? Thinking about confidentiality. If you're interviewing a lot of people, are they people who are going to be able to give you information that's relevant to the issues in the terms of reference? Or are you casting the net too wide? And is that going to cause gossip, speculation? Is it going to cause upset? Is it going to cause disruption to operations? So thinking about that. There also has to be a consideration of the context that an investigation is looking into. So there might be a specific allegation, but if you're looking at bullying or discrimination or safeguarding matters, you need to think about the wider issues. And the investigator needs to get to grips and understand those wider issues in the context in which the charity is operating. And the investigation, as I mentioned before, needs to look for evidence that both supports and contradicts the facts that have been alleged by the witnesses. And then that all needs to be pulled together into a cohesive report, which sets out the factual findings and then, from an employment point of view, would make a recommendation whether there's a case to answer to take forward, or whether there is information that supports the grievances that have been raised. And it's important to think that investigations are stressful and very difficult for everyone involved. So thinking about what practical and pastoral steps you're taking to support staff during these difficult times. So particularly if someone is suspended while they're under investigation, has someone been assigned to be their employee liaison? Have they been appointed to your employee assistance program? Have they been signposted to their GP if they're struggling with any mental health issues that might be connected to the stress of the process? Just need to think more widely about your duty of care to staff during particularly difficult and challenging times. Was there anything else you wanted to add there, Tabitha?
Yeah, I think there are a couple of things that are slightly different in this context. So the first is what you said about preparing a report. I've seen lots of employment-related reports, which are very detailed, almost like a sort of court process where you have the summary of all of the evidence both ways and the findings, and then a pack of all of the documents and the witness statements that led to that. That degree of rigour isn't always warranted for every other type of investigation. So do think about what your output is, your preferred output is at the beginning when you're commissioning it, because it will help then with the management of cost and time that is spent in going through the process. So that would be one thing that I would say, and I would echo what you say about this being a stressful process and thinking about the methodology with that in mind. So one of the questions that we've been asked as the seminar goes on is, what order should you do these things? You know, do you speak to the alleged perpetrator first or at the end, and how do you manage this? And it will be fact dependent, but generally speaking, what you would do is you would speak to them enough to let them know about the investigation and to manage expectations, with a view to then having the detailed interview where evidence is put to them for them to comment upon at the conclusion of it. But there may be circumstances where you change usual orders. Maybe that the police say, no, you can't speak to somebody in advance, or they're not available, or you're worried about collusion with various people, or evidence that you perhaps can't get being disposed of. So you do need to have a degree of flexibility around those things when you're thinking about it. The other thing to say is, when you're talking about investigations, it's important that you not only do a good job, but actually you are procedurally rigorous. So you do what you are required to do, either by the law and guidance, and or by your own internal policies, insofar as you can. So you may do what it seems to feel like a fair and balanced process, but actually, for example, you don't document everything, but your policy says you will do, and that will of itself create issues for you. So do think about actually what's required by the framework as we're going about it. Thanks, Jo. That's all I was going to say on it in the time that we have, but thank you.
So if we then move on to looking at the next steps, what to do once your investigation has been concluded, we move on to the next slide, please, Amy. We need to think about, once the investigation is concluded, reviewing the investigation, looking at the report. Does it seem adequate? Does it seem to cover everything? As Tabitha just said, does it meet all the requirements of your own internal policies and procedures? So you need to challenge that report to make sure that it does cover all of the bases. And you'll need to look at the recommendations from it. It may be that it recommends the need for disciplinary action, in which case you would move forward with your disciplinary policy, and you would invite the individual to a disciplinary hearing to answer the allegations formally against them. It may be that you need to move forward with a grievance meeting with the individual who raised the complaint, to go through the report with them, or the findings of the report, and to deliver any outcomes. And of course, it may be that the person, the decision maker, feels that they need more information. They might have supplementary questions for the investigator that need to be raised. A common issue that does come up is, how far should the report be disclosed and who should see it? And that does depend on the context and what's in the report. Certainly within the ACAS guidance around workplace investigations, there's a push towards transparency and sharing of information, but that's got to be balanced against data protection rights, commercial sensitivities, and thinking about, do the people who want to see it really need to see it? Is there a legitimate interest in sharing that report? Certainly for complicated grievances where there is a conflict between personalities, sometimes it's helpful to show the full report on the basis that it helps insight into certain behaviours, but that has to be very much balanced with how would anyone else who mentioned in that report feel about the sharing of that information, and whether there's a need to provide a summary rather than a full report, or whether in a grievance context it's better for the report to be explained verbally during the course of that meeting rather than the document itself shared. And if there are any concerns about data protection rights, there should be further advice sought in relation to that, thinking about whether the document might need to be redacted, whether full witness statements should be shared. Certainly if there's a disciplinary hearing, you would expect the full report and witness statements to be all made available to the person facing disciplinary action, so that they've got the full case against them to answer. And in terms of natural justice, you would expect them, for a fair hearing, to be able to understand all of the evidence against them. But it's slightly more nuanced with grievances in terms of what you would share. The report doesn't belong to the grievance bringer. Sometimes they feel that it's their report into their concerns and they should have it. But it's the organisation's report, and it's for you to determine how and what elements of it you share, and to be able to justify those decisions. I think that's everything I wanted to talk about in terms of next steps from an employment perspective. Tabitha, is there anything else that you wanted to add there?
I think the thing that I see from time to time is a view that an investigation is a static piece and it's not then followed up or reviewed. So that would be the fundamental piece of advice that I would give from this. First of all, if it's a report that gives you recommendations, do you then set a date by which you review that and check that those recommendations have been considered, if not implemented? If it's a conclusion of a process in relation to one complaint or one concern, has there been a review about the trend spotting that we talked about? Has it been picked up in that context? So I would just say I would caution against people thinking that once you have the report, that tends to be the end of what it is that you're doing. Sadly, it seems to be relatively early in the process on many situations.
And I would add to that from an employment perspective, if you aren't acting on the recommendations that come out of that report, and then there are further issues of similar nature, that your organisation is going to be subject to significant criticism if you knew about an issue and you didn't deal with it. So it's very important, as Tabitha said, to move forward with work to change cultures where it's needed or to address issues where it's needed. And I think that's where I hand over to you, Tabitha.
It is. So just to bring all of that together then, if we can move to the next slide, we're just trying to distill that down into some top tips for you. The integrity piece and the primacy of the safeguarding agenda and protecting people from harm means that I really think it's important to think about communications and support. So do inform those involved as soon as you can and do support them. And I think we can be a little bit inclined to think we know what support people need. But actually, I think it's always best to ask people what they would like. They may not want a named internal contact. They may be satisfied they've got external support. They may have some particular ideas around support that will help them through the process to enable it to go through as smoothly as it can. And I think the other thing is to manage expectations in the context of that. Quite often people say, well, we can't tell them what's going to happen and we can't tell them when because we just don't know yet. But I think saying we just don't know yet and those decisions are going to be, referred externally or referred to the board. But if we haven't heard by X date, we'll let you know where we've got to at that stage. I think that can be helpful, explaining the process and when they can expect to hear something, if at all. We talked about ensuring that the process is fair and proportionate, and I really think that's it's a critical consideration for charities. Yes, you need to follow your own procedures if you can, but if you can't or it doesn't feel appropriate, you can discuss that and agree a variation. But it's much better to face up to those and have a dialogue about it than not to. And I think that people will understand that you are going to need to make more attempt to go through a more rigorous process about something which is a higher risk. So thinking about the significance is important, and thinking about the extent to which the issue may be investigated separately. Certainly some of the things that I will see will involve lots of different investigations into very similar things. So in a safeguarding perspective, you may have a police investigation, you may have a local authority one, you may have a serious case review, you may have an inquest, you may have an independent review that you've commissioned. So be aware that a process can actually take much longer, and as we've talked about, can spiral, but make sure that you're doing what you can to control things and explain that to people. And I think that when you're dealing, particularly when you're dealing with concerns about the way the charity has acted or managed an issue, seeking external advice about what you're doing and sharing that can be useful. Avoid the perception of cover up at its worst, or at the least that you're marking your own homework. There is a real view, I think that in serious issues, particularly where you're talking about organisational cultures, that external investigation is the beacon of excellence, is best practice. But even if you don't feel the need to do that, actually seeking external advice and support to guide you in what it is you're doing and how can be useful. And I really do find it helpful to keep a chronology, and that chronology is not just what's happened, but also how you're managing it, because these things have a habit of spiraling or taking a detour, or you make a decision on the basis of one set of facts and then more comes to light. And it can be really difficult to go back and explain why it is you did what you did at the time you did it. And that sort of audit trail, not only of what's happened, but why, can be really helpful, particularly if the Commission are going to be looking into matters over time. And I think as part of this transparency and openness agenda, and informing people of the outcome where you can, and reflecting on those outcomes are really important. One of the things that we hear about in safeguarding terms is people not reporting matters because what was the point? Things have been reported and nothing's been done about it previously. So really explaining what was done about a concern that was raised can help to engender that sort of culture of openness and support that all charities are expected to try to deliver. And we've talked about all sorts of investigations in the course of this webinar, but for those that are serious incidents as defined by the Charity Commission, do remember your serious incident reporting duty, which could be the subject of a whole other session, but I can share the guidance, and indeed I will share the guidance with the follow-up to this session, just so that you're aware of what the Commission expect to be reported to them from the context of how the trustees are managing it. So that was what we wanted to share with you in the time that we had available. We've had a question which I've discussed as we've gone along, but does anyone else have any questions of us for now? I know that both Joe and I will be very pleased to answer any questions. If you want to take a little bit of time to reflect on today and have anything, our emails are on the slides. The slides and the recording will be shared, and the guidance to which we refer. So do please get in touch with us if we can help after today.